Justice Jackson, dissenting. I agree with every word of Justice Sotomayor's dissent. I write separately to emphasize a key conceptual point. The court's decision to permit the executive to violate the Constitution with respect to anyone who has not yet sued is an existential threat to the rule of law. It is important to recognize that the executive's bid to vanquish so-called universal injunctions is, at bottom, a request for this court's permission to engage in unlawful behavior. When the government says, "Do not allow the lower courts to enjoin executive action universally as a remedy for unconstitutional conduct," what it is actually saying is that the executive wants to continue doing something that a court has determined violates the Constitution. Please allow this. That is some solicitation. With its ruling today, the majority largely grants the government's wish. But in my view, if this country is going to persist as a nation of laws and not men, the judiciary has no choice but to deny it. Stated simply, what it means to have a system of government that is bounded by law is that everyone is constrained by the law, no exceptions. And for that to actually happen, courts must have the power to order everyone, including the executive, to follow the law, full stop. To conclude otherwise is to endorse the creation of a zone of lawlessness, within which the executive has the prerogative to take or leave the law as it wishes, and where individuals who would otherwise be entitled to the law's protection become subject to the executive's whims instead. The majority cannot deny that our Constitution was designed to split the powers of a monarch between the governing branches to protect the people. Nor is it debatable that the role of the judiciary in our constitutional scheme is to ensure fidelity to law. But these core values are strangely absent from today's decision. Focusing on inapt comparisons to impotent English tribunals, the majority ignores the judiciary's foundational duty to uphold the Constitution and the laws of the United States. The majority's ruling thus not only diverges from first principles, it is also profoundly dangerous, since it gives the executive the go-ahead to sometimes wield the kind of unchecked, arbitrary power the founders crafted our Constitution to eradicate. The very institution our founding charter charges with the duty to ensure universal adherence to the law now requires judges to shrug and turn their backs to intermittent lawlessness. With deep disillusionment, I dissent. Jackson dissent Section 1. To hear the majority tell it, this suit raises a mind-numbingly technical query. Are universal injunctions sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act, to fall within the equitable authority Congress granted federal courts in the Judiciary Act of 1789? Ante, at 841 to 842. But that legalese is a smokescreen. It obscures a far more basic question of enormous legal and practical significance. May a federal court in the United States of America order the executive to follow the law? Jackson dissent, Section 1, subsection A. To ask this question is to answer it. In a constitutional republic such as ours, a federal court has the power to order the executive to follow the law, and it must. It is axiomatic that the Constitution of the United States and the statutes that the people's representatives have enacted govern in our system of government. Thus, everyone, from the president on down, is bound by law. By duty and nature, federal courts say what the law is if there is a genuine dispute, and require those who are subject to the law to conform their behavior to what the law requires. This is the essence of the rule of law. Do not take my word for it. Venerated figures in our nation's history have repeatedly emphasized that the essence of our free government is leave to live by no man's leave, underneath the law to be governed by those impersonal forces which we call law. Youngstown Sheet and Tube Co. v. Sawyer, 1952, R. Jackson, concurring. Our government is fashioned to fulfill this concept so far as humanly possible. Id. 654 to 655. Put differently, the United States of America has a government of laws and not of men. Cooper v. Aaron, 1958. Frankfurter concurring, quoting United States v. Mine Workers, 1947. Frankfurter concurring in judgment. See also, e.g., Massachusetts Constitution, 1780, in 3 federal and state constitutions, 1893, F. Thorpe ed. 1909, J. Adams, Marbury v. Madison, 1803, Marshall for the court, United States v. Dixon, 1841, story for the court. That familiar adage is more than just mere rhetorical flourish. Cooper, 358 U.S. 23. It is the rejection in positive terms of rule by fat, whether by the fat of governmental or private power. Ibid. Indeed, constitutionalism has one essential quality. It is a legal limitation on government. It is the antithesis of arbitrary rule. Its opposite is despotic government, the government of will instead of law. C. McIlwain, Constitutionalism. Ancient and modern 1947. All constitutional government is by definition limited government. Those who birthed our nation limited the power of government to preserve freedom. As they knew all too well, constant experience shows us that every man invested with power is apt to abuse it, and to carry his authority as far as it will go. Montesquieu, The Spirit of Laws, in 38 Great Books of the Western World 69, 1952. But the founders reasoned that the vice of human ambition could be channeled to prevent the country from devolving into despotism. Ambition could be made to counteract ambition. The Federalist No. 51, C. Rossiter 1961. J. Madison, if there were, say, a constitution that divided power across institutions in such a manner as that each may be a check on the other, then it could be possible to establish government by and for the people and thus stave off autocracy. Ibid. See also Myers v. United States, 1926. Brandeis, dissenting, the doctrine of the separation of powers was adopted by the Convention of 1787 not to promote efficiency, but to preclude the exercise of arbitrary power. Through such separated institutions, power checks power. See Montesquieu, The Spirit of Laws, 69. Our system of institutional checks thus exists for a reason, so that the private interest of every individual may be a sentinel over the public rights. The Federalist No. 51, 322. Jackson Dissent, Section 1, Subsection B. The distribution of power between the judiciary and the executive is of particular importance to the operation of a society governed by law. Made up of free, impartial, and independent judges and justices, the judiciary checks the political branches of government by explaining what the law is and securing obedience with it. Mine Workers' Opinion of Frankfurter. C. Marbury, the federal courts were thus established not only to decide upon the controverted rights of the citizens as against each other, but also upon rights in controversy between them and the government. United States v. Lee, 1882. Quite unlike a rule of king's governing system, in a rule au flaw regime, nearly every act of government may be challenged by an appeal to law. Cooper, Opinion of Frankfurter. In this country, the executive does not stand above or outside of the law. Consequently, when courts are called upon to adjudicate the lawfulness of the actions of the other branches of government, the judiciary plays an essential part of the democratic process. Mine Workers. Were it otherwise, were courts unable or unwilling to command the government to follow the law, they would sanction a tyranny that has no place in a country committed to well-regulated liberty and the protection of personal rights. Lee. It is law and law alone that saves a society from being rent by internecine strife or ruled by mere brute power however disguised. Cooper, quoting Mine Workers. The power to compel the executive to follow the law is particularly vital where the relevant law is the Constitution. When the executive transgresses an act of Congress, there are mechanisms through which Congress can assert its check against the executive unilaterally, such as, for example, asserting the power of the purse. C. K. Stith, Congress Power of the Purse, 1988, describing Congress's ability to regulate executive branch activities by limitations on appropriations. But when the executive violates the Constitution, the only recourse is the courts. Eliminate that check, and our government ceases to be one of limited powers. Gregory v. Ashcroft, 1991. After all, a limit that does not confine the person on whom it is imposed is no limit at all. Marbury. Jackson Dissent, Section 2. With that background, we can now turn to this suit and focus on the ways in which the majority's ruling undermines our constitutional system. Justice Sotomayor has laid out the relevant facts. See ante, at 887 to 891, dissenting opinion, and I will not repeat what she has said. It suffices for my purposes to reiterate that, before these applications arrived here, 3 district courts had concluded that Executive Order Number 14,160, which attempts to alter the Constitution's express conferral of citizenship on all who are born in this nation, Amendment 14, Section 1, likely violates the Constitution. Those courts each thus enjoined the executive from enforcing that order anywhere, against anyone. 3 courts of appeals then declined to upset these injunctions during the pendency of the government's appeals. The majority now does what none of the lower courts that have considered Executive Order Number 14,160 would do. It allows the executive's constitutionally dubious mandate to go into effect with respect to anyone who is not already a plaintiff in one of the existing legal actions. Notably, the court has not determined that any of the lower courts were wrong about their conclusion that the executive order likely violates the Constitution. The executive has not asked us to rule on the lawfulness of Executive Order Number 14,160, but the majority allows the executive to implement this order, which lower courts have so far uniformly declared likely unconstitutional, nonetheless. Given the critical role of the judiciary in maintaining the rule of law, see Part I, Supra, it is odd, to say the least, that the court would grant the executive's wish to be freed from the constraints of law by prohibiting district courts from ordering complete compliance with the Constitution. But the majority goes there. It holds that, even assuming that Executive Order Number 14,160 violates the Constitution, federal courts lack the power to prevent the executive from continuing to implement that unconstitutional directive. As I understand the concern, in this clash over the respective powers of 2 coordinate branches of government, the majority sees a power grab, but not by a presumably lawless executive choosing to act in a manner that flouts the plain text of the Constitution. Instead, to the majority, the power-hungry actors are, wait for it, the district courts. See ante 837 admonishing district courts for daring to assert the power to order the executive to follow the law universally. In the majority's view, federal courts only have the power to afford the plaintiff complete relief in the cases brought before them. They can do nothing more. Ante at 851, and the majority thinks a so-called universal injunction, that is, a court order requiring the executive to follow the law across the board and not just with respect to the plaintiff, grants relief to non-parties. See ante 842 to 844. Therefore, the majority reasons, issuing such orders exceeds district court's authority. See ante 856. So many questions arise. The majority's analysis is fully interrogated and countered in Justice Sotomayor's dissent. My objective is to expose the core conceptual fallacy underlying the majority's reasoning, which to me also tends to demonstrate why and how today's ruling threatens the rule of law. The pillar upon which today's ruling rests is the majority's contention that the remedial power of the federal courts is limited to granting complete relief to the parties. Ante, at 851, and the majority's sole basis for that proposition is the practice of the High Court of Chancery in England. Ante, 842 to 843. But this cramped characterization of the judiciary's function is highly questionable when it comes to suits against the executive. That is, even if the majority is correct that courts in England at the time of the founding were so limited, and I have my doubts, see ante 895 to 897. Sotomayor, J., dissenting. Why would courts in our constitutional system be limited in the same way? The founders of the United States of America squarely rejected a governing system in which the king ruled all, and all others, including the courts, were his subordinates. In our constitution-centered system, the people are the rulers and we have the rule of law. So, it makes little sense to look to the relationship between English courts and the king for guidance on the power of our nation's judiciary vis-a-vis its executive. See the Federalist No. 69, 416 A. Hamilton, explaining how the president differs from the king, including because the person of the King of Great Britain is sacred and inviolable. There is no constitutional tribunal to which he is amenable. Indeed, it is precisely because the law constrains the government in our system that the judiciary's assignment is so broad, per the Constitution. Federal courts entertain suits against the government claiming constitutional violations. Thus, the function of the courts, both in theory and in practice, necessarily includes announcing what the law requires in such suits for the benefit of all who are protected by the Constitution, not merely doling out relief to injured private parties. Put differently, the majority views the judiciary's power through an aperture that is much too small, leading it to think that the only function of our courts is to provide complete relief to private parties. Sure, federal courts do that, and they do it well. But they also diligently maintain the rule of law itself. When it comes to upholding the law, federal courts ensure that all comers, i.e., everyone to whom the law applies and over whom the court has personal jurisdiction, including and perhaps especially the executive, know what the law is and, most important, follow it. Jackson Dissent, Section 3. Still, upon reading the court's opinion, the majority's foundational mistake in mischaracterizing the true scope and nature of a federal court's power might seem only marginally impactful. Indeed, one might wonder, why all the fuss? After all, the majority recognizes that district courts can still issue universal injunctions in some circumstances. See ante at 851 to 853. It even acknowledges that the lower courts may reimpose the same universal injunctions at issue in these cases, if the courts find on remand that doing so is necessary to provide complete relief to the named plaintiffs. See ante at 854. From the standpoint of outcomes, that's all welcome news. But as I explain below, from the perspective of constitutional theory and actual practice, disaster looms. What I mean by this is that our rights-based legal system can only function properly if the executive, and everyone else, is always bound by law. Today's decision is a seismic shock to that foundational norm. Allowing the executive to violate the law at its prerogative with respect to anyone who has not yet sued carves out a huge exception, a gash in the basic tenets of our founding charter that could turn out to be a mortal wound. What is more, to me, requiring courts themselves to provide the dagger, by giving their imprimatur to the executive branch's intermittent lawlessness, makes a mockery of the judiciary's solemn duty to safeguard the rule of law. Jackson Dissent, Section 3, Subsection A. Do remember, the executive has not asked this court to determine whether Executive Order Number 14,160 complies with the Constitution. Rather, it has come to us seeking the right to continue enforcing that order regardless, i.e., even though 6 courts have now said the order is likely unconstitutional. What the executive wants, in effect, is for this court to bless and facilitate its desire to operate in 2 different zones moving forward. One in which it is required to follow the law, because a particular plaintiff has secured a personal injunction prohibiting its unlawful conduct, and another in which it can choose to violate the law with respect to certain people, those who have yet to sue. In the first zone, law reigns. For the named plaintiffs in the suits before us, for example, the lower court's determination that Executive Order Number 14,160 is likely unconstitutional and cannot be implemented has teeth. Per the court's orders, the executive is prohibited from denying citizenship to the offspring of the named plaintiffs. See ante at 861, leaving the injunctions in place to the extent necessary to provide complete relief to each plaintiff with standing to sue. Within this zone, the court's rule of decision, that Executive Order Number 14,160 is likely unconstitutional, applies. But with its ruling today, the majority endorses the creation of a second zone, one in which that rule of decision has no effect. In this zone, which is populated by those who lack the wherewithal or ability to go to court, all bets are off. There is no court-issued mandate requiring the executive to honor birthright citizenship in compliance with the Constitution, so the people within this zone are left to the prerogatives of the executive as to whether their constitutional rights will be respected. It does not matter what 6 federal courts have said about Executive Order Number 14,160. Those courts are powerless to make the executive stop enforcing that order altogether. In effect, then, that powerlessness creates a void that renders the Constitution's constraints irrelevant to the executive's actions. Of course, the executive might choose to follow the law in this zone as well, but that is left to its discretion. And the Solicitor General has now confirmed that, in the absence of a personal injunction secured by a particular plaintiff, This executive's view is that compliance with lower court rulings on matters of constitutional significance is optional. I am not the first to observe that a legal system that operates on two different tracks, one of which grants to the executive the prerogative to disregard the law, is anathema to the rule of law. Thus, the law-free zone that results from this court's near elimination of universal injunctions is not an unfamiliar archetype. Also eerily echoing history's horrors is the fact that today's prerogative zone is unlikely to impact the public in a randomly distributed manner. Those in the good graces of the executive have nothing to fear. The new prerogative that the executive has to act unlawfully will not be exercised with respect to them. Those who accede to the executive's demands, too, will be in the clear. The wealthy and the well-connected will have little difficulty securing legal representation, going to court, and obtaining injunctive relief in their own name if the executive violates their rights. Consequently, the zone of lawlessness the majority has now authorized will disproportionately impact the poor, the uneducated, and the unpopular, i.e., those who may not have the wherewithal to lawyer up and will all too often find themselves beholden to the executive's whims. This is yet another crack in the foundation of the rule of law, which requires equality and justice in its application. Papachristou v. Jacksonville, 1972. In the end, though, everyone will be affected, because it is law's even-handed application to minorities as well as majorities, to the poor as well as the rich, that holds society together. Ibid. The majority skips over these consequences. Ante, 859. No one denies that the power of federal courts is limited, both by the Constitution and by Congress. But the majority seems to forget, or ignores, that the Constitution and Congress also limit the power of the executive. In addition, it is indisputable that the executive's power to leverage physical force in a manner that directly threatens to deprive people of life, liberty, or property creates uniquely harmful risks when unconstrained by law. But the majority today roots its holding in a purported statutory limitation, not a constitutional one. Ante, at 841, N4. And as I have explained, our Constitution gives federal courts the authority to order the executive to stop acting unlawfully. See Part 1, Supra. To the extent Congress has attempted to strip federal courts of that power via the Judiciary Act, and to be clear, I do not think it has, for the reasons Justice Sotomayor discusses, see Ante, at 900 to 908, it is powerless to do so. The bottom line is this. If courts do not have the authority to require the executive to adhere to law universally, a dual-track system develops in which courts are ousted as guardians in some situations and compliance with law, sometimes, becomes a matter of executive prerogative. But there can be no free society without law administered through an independent judiciary. Mine workers, opinion of Frankfurter. If one man, even a very important man, and even a democratically elected man, can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. Ibid. Jackson Dissent, Section 3, Subsection B. This leads me to another potentially destructive aspect of today's decision: the court's dismissive treatment of the solemn duties and responsibilities of the lower courts. Sworn judicial officers must now put on blinders and take a see-no-evil stance with respect to harmful executive conduct, even though those same officials have already announced that such conduct is likely unconstitutional. Yes, certain named plaintiffs have brought particular lawsuits seeking protection of their legal rights. But their claim is that Executive Order Number 14,160 violates the Constitution. If the court agrees with them, why on earth must it permit that unconstitutional government action to take effect at all? I have already explained why the majority's answer. Because the court is powerless to do anything but give complete relief to those parties, is wrong in terms of the actual scope of federal court's authority. See Part I Supra. I now observe that this response also erroneously suggests that a court does something wrongful when it imposes a universal injunction in a single plaintiff's lawsuit, akin to giving a windfall to those who do not deserve the law's protection because they have not sued. Ante at 844, 847 to 850. This way of conceptualizing universal injunctions mistakes that remedy for the unearned spoils of particular adversarial engagements, rather than a necessary tool employed to defend the Constitution by reinforcing pre-existing rights. Here is what I mean. Our Constitution indisputably confers individual rights that operate as unequivocal protections against government action. Thus, a constrained executive, that is, one who is bound by the Constitution not to violate people's rights, is a public benefit, guaranteed to all from the start, without regard to the nature or existence of any particular enforcement action. Properly understood, then, when the executive violates those pre-existing rights in a non-particularized manner, a universal injunction merely restores what the people were always owed. That remedy does not improperly distribute an unearned benefit to those who did not have the temerity to secure it for themselves by filing a lawsuit. Or consider it the other way. When a court is prevented from enjoining the executive universally, after the executive establishes a universal practice of stripping people's constitutional rights, anyone who is entitled to the Constitution's protection but will instead be subjected to the executive's whims is improperly divested of their inheritance. The Constitution is flipped on its head, for its promises are essentially nullified. So, rather than having a governing system characterized by protected rights, the default becomes an executive that can do whatever it wants to whomever it wants, unless and until each affected individual affirmatively invokes the law's protection. A concrete example helps to illustrate why this turnabout undermines the rule of law. Imagine an executive who issues a blanket order that is blatantly unconstitutional, demanding, say, that any and all political foes be summarily and indefinitely incarcerated in a prison outside the jurisdiction of the United States, without any hearing or chance to be heard in court. Shortly after learning of this edict, one such political rival rushes into court with his lawyer, claims the executive's order violates the Constitution, and secures an injunction that prohibits the executive from enforcing that unconstitutional mandate. The upshot of today's decision is that, despite that rival's success in persuading a judge of the unconstitutional nature of the executive's proclamation, the court's ruling and injunction can only require the executive to shelve any no-process incarceration plan that targets that particular individual, the named plaintiff. The executive can keep right on rounding up its other foes, despite the court's clear and unequivocal pronouncement that the executive order is unlawful. The majority today says that, unless and until the other political rivals seek and secure their own personal injunctions, the executive can carry on acting unconstitutionally with respect to each of them, as if the Constitution's due process requirement does not exist. For those who get to court in time, their right not to be indefinitely imprisoned without due process will be protected. But if they are unable to sue or get to the courthouse too late, the majority says, oh well, there is nothing to be done, despite the fact that their detention without due process is plainly prohibited by law. A Martian arriving here from another planet would see these circumstances and surely wonder, what good is the Constitution then? What really is this system for protecting people's rights if it amounts to this, placing the onus on the victims to invoke the law's protection, and rendering the very institution that has the singular function of ensuring compliance with the Constitution powerless to prevent the government from violating it? Those things Americans call constitutional rights seem hardly worth the paper they are written on. These observations are indictments, especially for a nation that prides itself on being fair and free. But after today, that is where we are. What the majority has done is allow the executive to nullify the statutory and constitutional rights of the uncounseled, the under-resourced, and the unwary by prohibiting the lower courts from ordering the executive to follow the law across the board. Moreover, officers who have sworn an oath to uphold the law are now required to allow the executive to blatantly violate it. Federal judges pledge to support and defend the Constitution of the United States against all enemies, foreign or domestic. 5 U.S.C. Section 3331. They do not agree to permit unconstitutional behavior by the executive or anyone else. But the majority forgets or ignores this duty, eagerly imposing a limit on the power of courts that, in essence, prevents judges from doing what their oaths require. I view the demise of the notion that a federal judge can order the executive to adhere to the Constitution, full stop, as a sad day for America. The majority's unpersuasive effort to justify this result makes it sadder still. It is the responsibility of each and every jurist to hold the line. But the court now requires judges to look the other way after finding that the executive is violating the law, shamefully permitting unlawful conduct to continue unabated. Today's ruling thus surreptitiously stymies the judiciary's core duty to protect and defend constitutional rights. It does this indirectly, by preventing lower courts from telling the executive that it has to stop engaging in conduct that violates the Constitution. Instead, now, a court's power to prevent constitutional violations comes with an asterisk. A court can make the executive cease its unconstitutional conduct, but only with respect to the particular plaintiffs named in the lawsuit before them, leaving the executive free to violate the constitutional rights of anyone and everyone else. Make no mistake, today's ruling allows the executive to deny people rights that the founders plainly wrote into our Constitution, so long as those individuals have not found a lawyer or asked a court in a particular manner to have their rights protected. This perverse burden shifting cannot coexist with the rule of law. In essence, the court has now shoved lower court judges out of the way in cases where executive action is challenged, and has gifted the executive with the prerogative of sometimes disregarding the law. As a result, the judiciary, the one institution that is solely responsible for ensuring our republic endures as a nation of laws, has put both our legal system and our system of government in grave jeopardy. The accretion of dangerous power does not come in a day. Youngstown, opinion of Frankfurter, but it does come from the generative force of unchecked disregard of the restrictions that fence in even the most disinterested assertion of authority. Ibid. By needlessly granting the government's emergency application to prohibit universal injunctions, the court has cleared a path for the executive to choose law-free action at this perilous moment for our Constitution, right when the judiciary should be hunkering down to do all it can to preserve the law's constraints. I have no doubt that, if judges must allow the executive to act unlawfully in some circumstances, as the court concludes today, executive lawlessness will flourish, and from there, it is not difficult to predict how this all ends. Eventually, executive power will become completely uncontainable, and our beloved constitutional republic will be no more. Perhaps the degradation of our rule of law regime would happen anyway. But this court's complicity in the creation of a culture of disdain for lower courts, their rulings, and the law as they interpret it, will surely hasten the downfall of our governing institutions, enabling our collective demise. At the very least, I lament that the majority is so caught up in minutiae of the government's self-serving, finger-pointing arguments that it misses the plot. The majority forgets or ignores that with all its defects, delays, and inconveniences, men have discovered no technique for long-preserving free government except that the executive be under the law, and that the law be made by parliamentary deliberations. Id. At 655, opinion of R. Jackson. Tragically, the majority also shuns this prescient warning. Even if such institutions may be destined to pass away, it is the duty of the court to be last, not first, to give them up.